Well, so quite an interesting discussions. I will give some comments. I will also discuss with Suzuki-sensei about Japanese practice. Maybe. The one point that he just mentioned is the declaratory nature of this RSD refugee determination system. As I told you yesterday, the Japanese system, the Japanese local system, Immigration and Refugee Determination Act, the authority belongs to the Minister of Justice. So in this sense, lawyers always bring the court after the negative decision made by Minister of Justice. So the point is, I think this decision is fair or not, or something like that. So in this sense, kind of a backward for the time. But as he mentioned, the convention just requires the declaratory decision, just time of the decision, because it's a forward-looking, future-looking. It's not a point is not just a past, just a possibility when he or she be deported. So in this sense, another sort of litigation might be considered. So Suzuki Sensei also suggested some sort of probably just request of the court, the judge, to order the Ministry of Justice to the based on the finding of the court at the time of the decision. So that is confirming, that is declaratory. He is a refugee, so that's why you, Minister of Justice, have to determine refugee status, something like that. Maybe this kind of litigation could be possible, so they're seeking for that. And also, I just discussed another way of the not only such administrative complaint procedures, but also civil procedure court also allow any citizens, even under Japanese jurisdiction, even foreigners as you, ask the confirmation of your rights. So just a confirmation. So that means refugees are kind of important rights of the person. Just be asked court to determine refugee status, just bypass of the Ministry of Justice. So this is also another challenge because the Japanese system itself must be considered. So I think that is a very much strategic things. And the second point, I think this concept of persecution. Yeah, I also translated this Professor Hathaway's long book into the Japanese version partly, but persecution is a very much tricky word in Japanese. We call it hakugai. Hakugai is in Japanese connotation very vague and very subjective. It's not so well understood as a pattern. So depending on how you feel, something like that. So in this sense, it's not easy to be as legal terms under Japanese legal system. So in this sense, probably, I guess the judges will just rely on some kind of objective terminology of the life or sort of death or such a strong word, of course, as a symbolic things. But this is a kind of mirroring of how Japanese public human rights awareness or standard of the human rights, unfortunately. So Japanese, as you may know, we also suffered a lot of human rights violations, especially the overtime work and so on. We didn't realize this is a human rights issue also, something like that. So in this sense, kind of unfortunately, still the Japanese public, ordinary people, doesn't think that this kind of rape is a kind of persecution. Just is a kind of crime. Just a crime. It's not persecution. But I think also Ministry of Foreign Affairs also endorsing the human security ideas. Human security ideas are not only human rights but also dignity.
Yes.
Dignity is another word.
Yeah.
What is dignity? But I think this sort of new approach, especially from the international context, if Japan want to take a leadership of the human security, of course, dignity should be respected. So in this sense, we should also enlarge for the interpretation. But unfortunately, the Japanese legal system always based on the precedent. Only the local judgment will be referred, not to refer to the other countries' judgment or international court and so on. Unfortunately, because they think this is a sovereign Japan. But as I suggested, this is a convention. So in this sense, I think the judges also under the Japanese constitutional obligation to respect the internationalism provided by Article 98, paragraph 2. So in this sense, international law must be respected. This is a higher hierarchy than the local law. So in this sense, I think the reason to learn what means this such persecution in the international context. So that is sort of we have to discuss Japanese judiciary personnel. So these are my thoughts. Thank you very much.
That's very helpful comments. And as I said, this is an academic exercise to discuss everything related to it. It's not for us to say what's right or what's wrong, but that's you've explained a couple of things. And I should say also, as we'll discuss when we look at some of these cases, there are judges moving along that path, exactly that you were saying, towards a better human rights understanding or a better human dignity approach. There's one case that we looked at there which actually goes on and there's other problems with it, but basically the judge is setting out that you've got to look at the UDHR and the whole concept of human rights and everything that's built into it in the definition. And a number of them, unfortunately not doing it in the round or pulling it together, but there are some of them making assessments of risk at a variety of level, from extremely loose ones to extremely perverse ones at the over the top ones at the other end. So there are a number of decisions that we've noticed in there, even that variety of 15 or so decisions that we've looked at, where there are judges clearly moving in that direction from the things they're saying. It's not in any way yet pulled together, or the only one that really does go a long way is this Sri Lankan decision. Anyway, let's just look at the one more comparison before we go into the detail of cases. And this is on burden and or standard of proof comparisons. Several Japanese judgments state that there are no standards defined in the Refugee Convention, so it is construed these should be in accordance with the legislative policies of the contracting state. And hence, not only is the burden stated rightly that the claimant has to make their own case, that's quite right, but also they must submit objective evidence and material to clearly demonstrate eligibility to qualify as a refugee. So that's sort of partly right, is probably the best way of putting it. But as can be seen, when you look at the differences, the unique nature of refugee law, which we did in the first place, and with all these points about it being not domestic law but international law, that it's a shared burden of proof, and these things are all relevant, and thus a strict insistence on evidence demonstrating eligibility is not really comparative to the approach taken internationally. So that there is a move towards a more, and it's gone on correctly from early stages, a shared burden of proof, because that really recognises the reality of the situation. The state has far more ability to find out exactly what's happening in every country around the world, as long as it shares it with the other party, and also to research it and to provide libraries and all that sort of thing. In fact, it's pleasing that the refugee division, or whatever it's called now, service, has got its own small, I gather, and we're meeting the guy tomorrow, COI division that's been set up to have to give research. I don't know whether it shares the information with council yet or what happens, I don't know, but it'll be interesting to see where that comes from, which is what we implemented in New Zealand, and I think about 1994. So, you know, they're getting there gradually, one might say. So because without that core information, then the claimants simply, in reality, particularly, let's say there, as many of them are, uneducated or ill-educated, where are they going? No money, no pro bono legal support in this country, to come up with sophisticated, detailed knowledge of exactly what their predicament is on return, let alone what it might have been 10 years ago, is utterly unrealistic. Whereas the state has clearly the ability to look at somebody with that profile and say, this is what's happening. And in this day and age, you can find out, as I was saying, you can know what's going on in downtown Mogadishu today, sort of style, which you never did 20, 30 years ago.
Google Maps.
Yeah, Google Maps, exactly. So the standard of proof also is a worrying one, where it's strong variance from international standards. It appears that the judges consider they should follow Article 7 of the Administrative Case Litigation Act and adopt a civil standard, and this is, which they state, and a number of decisions say this, a high degree of probability beyond reasonable doubt. Wow, I have no idea what that means. I'm sorry, it's utterly beyond me. Internationally, this standard would sound firstly confusing, because you're confusing probability with doubt, and you've got high degrees. What are a high degree? I don't know. If something's beyond reasonable doubt, in English terms, that means it's almost a certainty. It's the criminal standard, we call it. Probability is a standard used in common law at 50% balance of probability thing, but to put the two together in one statement, I don't know. I think it's meant to be an extremely high one, and well above, in common law terms anyway, the criminal standard. It's almost virtual certainty that you're looking for. And this standard sadly overlooks the whole reality we were talking about, the humanitarian nature of refugee protection. So it just doesn't recognise the reality of refugees in flight from well-founded fear. And the reality is that the universal standard for risk assessment is set at real chance, real risk, reasonable likelihood, serious possibility, all of these equating to the same reality versus remoteness test. And that, I've always thought, is the best way of looking at it. Is this a real risk or is it remote? And if you do those, you'll give yourself pretty good guidance. It's not a low standard, it's a standard that requires reality to it, but it depends, as you know, you probably all heard the story of the 1 in 10 on the bus. We're going to kill the ISIS people, stop your bus and say, right, every 10th one we're going to shoot. Is there a real chance of being shot? It certainly wakes you up. And so you can see it's not something that you measure at that high standard. And the lack of reality in that test, that standard of proof, is that's beyond what would happen in any civil case or any criminal case. Why should you have to get it? And let's recognise, in a domestic case, you have the witnesses before you, you can cross-examine them, you can call them in, you can subpoena them, you can get evidence directly, viva voce, face-to-face, from the people. You can't do that with somebody who's in fear of persecution in Sri Lanka or Syria or where it is. You're not going to call witnesses to check these things. It just is impossible. And so you've got a person who's struggling, as you probably are with my English, but with another language, and to just think that you can reach that level, I'm sorry, I don't know how, it's just beyond me, but anyway. Okay.
What's the general view in the room? What do you think the standard should be? How much risk is enough? And this is part of the problem in Japan.
Yeah.
The courts here do not differentiate between making the findings of fact.
And the risk.
Yes, we are satisfied this man is Iranian. We are satisfied he's homosexual. We are satisfied the country information says that homosexuals get persecuted in Japan. Those are the facts. Did I say Japan? Sorry, Iran. Sorry. I got jet lag. The findings of fact need to be made before you turn to the question of whether they establish a risk of serious harm. There are actually two separate analyses going on. Japanese decisions in the courts don't really differentiate. They just make one global finding. And this is your point, that they say we've got to be satisfied beyond reasonable doubt that the person's a refugee. But within that finding, there need to be all these other things going on. I mean, in New Zealand and in most other countries around the world, we also need to make findings of fact, and we have to be satisfied that we do find these facts to be established. And it's a little like an on-off switch. You either find them established or you don't. But if you're not sure, you need to give the benefit of the doubt.
Not to the risk.
Not to this is not about the risk. This is about establishing the facts. And this is for all the reasons that Allan says, that the person cannot go back to their home country. They can't go up to the persecutor and say, "Excuse me, just before you harm me, could you provide me with some written evidence that you're going to harm me?" This is the real world we live in. So it is critically important that the benefit of the doubt is given. Well, we don't have to be stupid about it. When people fail to produce evidence which is available to them, yes, we should be worried about it. We'll talk about the Syrian decision. Why did this man not produce the judgment that he said he had? It's an important point. He shouldn't get the benefit of the doubt where he's not produced something that he should be able to. But ultimately, where you're happy he's done what he reasonably can, you need to give the benefit of the doubt. You can't be giving the benefit of the doubt when there are tests that are saying it's got to be established beyond reasonable doubt. The language is not compatible. And so let's park the findings of fact for a minute and just talk about the second part. And this is what Alan's talking about here, the real chance test. Let's look at the bus example. You're on holiday in Syria. No, not many do, I know. But just imagine you were. No, okay. Let's say
extraordinary man.
No. Let's say you work for the Red Cross, and you're in Syria, and you're going to take a bus across the desert to some other place, and you receive intelligence that Islamic State is going to stop the bus on the way. They're going to hijack the bus, and for one of their charming desert videos that they make, they're going to take one person off the bus and behead them for their video, so they can put it on YouTube or somewhere. There are going to be 10 people on the bus. You're one of them. Put your hand up, if you're going to get on that bus. No, and I wouldn't either. You can see that as low as 1 in 10, when it's brought home to you, the risk is unacceptable to you. So, to be in this umbrella of beyond reasonable doubt, to be talking about the degree of risk is nonsensical. The degree of risk, it's not just for fun that we talk about a real chance or a real risk. The person sitting before you as a decision maker has all of the challenges that Allan talked about. They can't go and get you information. They've probably got no money. If they've got a lawyer, they're probably on legal aid, which doesn't pay very much. They don't speak your language. They don't understand your culture. They don't know what's in your mind. And you're asking them to prove what somebody else in another country is going to do in the future. This is surreal. It has to be at a level, a realistic level of a real chance. You can't expect people to establish more than that. You want to look for a prime reason for Japan's low rate of acceptance of refugee claims. You don't need to look further than this. This is a major departure from virtually every other jurisdiction in the world. Sorry, Allan. That's my little point.
That's all right. Yeah, it's a good point. And just before we leave it, and just that partly in that paper, the structured approach paper with the step-by-step one, which I think has been translated into Japanese, that's why the steps are there. You know, a good person doing the whole thing wouldn't go through it quite as strictly as all that. But if you do the credibility assessment as the first thing, in other words, finding or the facts you're going to accept, which is what Martin's talking about, to go on, and then first of all, once you've found the level of harm, to go to the risk test, is the only correct way of doing it. And the international treatment of credibility really is there is no cut-off point. There is no standard of proof. You put together all the bits and pieces and that you're prepared to accept, and if you don't accept parts of them, you have to give reasons, good reasons, why you're refusing them. And so you will then end up, quite often, with partial credibility acceptance. And then you must make a summary of that in your decision and say, right, what I accept is something like Martin was saying, this man is from Syria, he's so many years old and he's lived there and his brothers have gone overseas because they were in the same movement, or all these sorts of things. So you've then got a bundle of characteristics, is what I like to call them. You could call it a profile, but that sounds a bit criminal. But it's more, so you've got that bundle of characteristics. You can then take that on and apply the real chance or the risk test to it. But there's no cut-off point, as a famous judge in the UK called a probabilistic cut-off point. In other words, this is bringing the probabilities into it. There's no point. It's all the material things that you're going to take into account in reaching what you accept. And so the law of evidence and so forth really has and this is why it's a piece different to anywhere else. It's not like a domestic situation, as I spoke about before. We can get everybody in and let's check it and double check it and triple check it and it's the same language and everything else. It is totally different to that. So it's all these snippets sometimes of information, small pieces, large pieces, that you put with materiality. You don't want immaterial things brought into it, but that's going to give you that assessment. And certainly not ordinary men. It's this person in front of you with that bundle of characteristics, what's going to happen when they go back to where they came from or their nationality. So that's the difference. And then when you've got that, then you can do a risk test. That's why it's got those boxes in it. That's the reason for doing that. And really, as agreed by the 70 or 80 judges who did the original work in it and every other judge I've spoken to since, that analysis, if you do it, you won't get it wrong. It's the way of making sure you end up with a solid decision. But you've got to make sound reasoning as you go along. You just can't, if you're going to knock something of somebody's credibility, you've got to give sound reasons why. And when we look, if you look at credibility, all those 40 or 50 reasons that are set out in that same paper, that's why they were pulled together, to give guidance to people as to, particularly on fairness, hearing the other side and so forth, which sadly, if you're doing these things on the papers, as one of these judges seem to do, and go through item by item by item, and in effect do all sorts of credibility assessments in them, is the appellant there? Have they given evidence? Have they got to write a reply? What happens? Doesn't seem so. So all those things just completely breach the fairness requirements for assessing such cases. Anyway, let's move on. Yeah, that's right. The chart is just part of the whole thing. We had, that chart, the blue chart. Anyway, we can give them to tomorrow.
Yep. Yep.
So we'll give you all one of our lovely blue charts that you can thank Martin for producing them, because I got completely befuddled trying to use Visio or something. And he just said, I'll do that. Next day, here's this beautiful chart. So if ever you need a techno wizard, here's your man. Okay, so as I said, that's what I was saying, there's no probabilistic cutoff. And everything material must be weighed up and reasoned in their totality. Thus, in this way, we find the accepted characteristics, and that's used in the risk. It's often the term used, more a UK term, is in the round, or in the totality of the evidence. It's hard to tell from the material we looked at to see whether we're comparing facts with like with like. Certainly in most of those decisions, like the Syrian one and a number of others, where the courts have gone through sort of item by item or sort of fact by fact or something, and they tend to go through and make a separate decision on every one of these facts. Occasionally, I think it's maybe the Iranian one, that's got summaries every now and then of certain blocks of fact. So, but that, and then making decisions on every one of them and including a risk test in it. It's a somewhat bizarre way of doing it. It's certainly because the person in front of you is not made up of 1,000 little pieces. They've got one set of experience and one risk to them. So that's the reason why it's got to be done in the round, all of the things together and what you accept and what you don't. So maybe that's what they're looking for, but if you apply a risk test to every one of those items of fact, you've ended up with sort of nothing before you start. And so that it is no way of finding the risk to anybody, because you just don't know what characteristics. They're trying to knock it out every time. You can't have a well-founded fear because I don't believe this. You can't have a well-founded fear because I don't believe this fact. And so that you end up, when you go through these decisions, with this sort of mishmash or this sort of just a whole lot of pieces of evidence dealt with and nothing done, where frankly it just shouldn't be done. You just say, this is what I'm prepared to accept, this is what I'm not. These are the reasons that I won't. And sound reasoning. So there's just no logic in the way the cases are put together at the court level. And even one or two of those cases go to the High Court and do that, where that just is amazing to me. High courts are for error of law, they're not for fact finding. And so, anyway, so we'll, as I say, when our discussions maybe tomorrow, we'll look at that more closely. At the district court level, full files from this is what I want some questions really that you can talk about today or tomorrow. Can you just look through those? And don't have to give me an answer now, but these are the questions that we've got to sort of enhance our investigation. At the district court level, are the full files of the MOJ and the RECs, or whatever they call them, the examination counsellors, including their reasoning, available to both sides? Question one. In the interview hearings that the MOJ has and the Rex have, is it all, the evidence, including COI, experts, witnesses or whatever you get, shared so all parties can examine and cross-examine? How are credibility and fairness issues handled at all instances, and what's the role of counsel? At court, are appellants allowed to attend? With counsel, can they give evidence? And what happens in relation to credibility, fairness issues, to hear the other side? Is the court procedure investigative, in other words, court making questions as well, or is it adversarial, purely what's put up from either side, or a mix of both, which tends to happen in more and more courts around the world in this field because it's the best way of a shared burden being explored, and as they call it in Europe, the protection point. In other words, if the judge, and this is not really a requirement from the Refugee Convention, but is in the European Convention on Human Rights, the judge has a role to look at protection points themselves. So you just can't leave a point where this looks as though it's obvious, even if counsel haven't realised that there's a persecution point or a convention reason point that should be raised. The judge can enter the arena, even in an adversarial court, and take that point up. Is any fresh evidence allowed before the court? And does the High Court ever just take an error of law approach, as we would call it, a certiorari approach? So, anyway, I just skipped through those just really for the lawyers amongst you. If you can, or anybody that knows, if you can re-look at those, or as we go along now, anytime, if we can get some answers to those, it'll also help clarify this whole academic inquiry. All right, anybody want to comment now, or better to leave it for tomorrow's discussions?
Can I add something?
Yeah,
If we're
sure.
talking about the lawyers. How many people here are lawyers? 2?
3.
3?
Yep. Law student.
Here's a thought for you. Yukari and I were talking about this in the break. Where do judges get the information that they need to put into decisions? We can look at brilliant decisions written by judges and be full of admiration for their wisdom and their ability to dispense the law. The truth is, in every single case that's ever come before me, I have had to deal with the submissions and the evidence put before me by the lawyers. I can't ignore it. And I wonder why Japanese judges never deal with international law. Why do Japanese judges never have to say in their decisions, well, I know international law says that persecution or being persecuted is serious harm arising from breaches of human rights and an absence of state protection, but I'm not going to decide that. I'm going to decide that persecution means what would be intolerable for the reasonable person in terms of a threat to their life or freedom. Why do Japanese judges never have to address international law? And I wonder whether the lawyers are in fact ever putting it before the judges. Because if they were, I can promise you the judges would be required to address it. Now so you appear before a judge and you say, my client was wrongly declined by the Ministry of Justice because the Ministry of Justice failed to take into account international law about what being persecuted means. And here is all the international law, here's the the stack of cases from all around the world on this. The judge is not going to be able to ignore that. They will have to deal with it. Maybe they will say, I reject it. But as soon as they say, I reject it, you've got something you can go to a higher court with. You're not going to get a change just because judges have the inspiration to make a change. Judges need to be prompted and pushed by lawyers. That is your role.
Just before we're too critical of them, in the Ethiopia 1 case, you tried. And even the judge acknowledges it. So that, because clearly it says in there, the plaintiff, that was whoever the lawyers were, some of them may be in this room, contend that in the light of persecution, in the usual sense, the arrangement of the sections, the purpose and the intention of the draftsperson, people of the Refugee Convention, the meaning of persecution, not being persecuted, in the refugee is not limited to deprivation of life and physical freedom, but includes serious human rights violations. That's what led him into then to this crazy stuff about 31 and 32 and 33, and that was how that judge or judges refuted a totally valid argument that that was the case. And I think you probably took that to the appeal, to the High Court, didn't even deal with it in Ethiopia 2. That went off into another fact-finding episode, which just didn't even make the point at all. So, yeah, I can see that probably some of you are putting those sorts of points forward, but as we would say, or Martin would say, they're being shot down.
It's okay to put them forward and be shot down.
Yeah.
Then you've done your job. You can't help the judge shooting them down.
Yeah.
But getting it dealt with by the judge enables you to go to a higher court.
Yeah.
Take it to a higher court.
Yeah.
But it is like water dripping on a stone. Ultimately, it wears it away.
Yeah. Or particularly.
Are there any counselor to defend the Japanese court?
Yes.
Well, yeah, maybe that is also the majority view that the court judges think very differently, probably because anyway, the supremacy of the state, also sovereignty. So sovereignty belongs to final authority for the interpretation of any law. Yeah.
But the courts in every country in the world
Yes.
understand that and think that. Yeah. It doesn't mean they can't look at what other countries do and agree that the approach is right. This is his point, that just because they're not required to follow it, because it's not binding, doesn't mean that they shouldn't.
Yeah, of course. So in this sense, I think our Japanese professors also be responsible for this more translating this English president or English argument into Japanese. You just cited some scholars, academics, mostly the English-speaking countries.
Yeah.
In this sense, English dominated.
Yeah.
So this kind of course, original language, English or French. So Japanese, just translation. So in this process, in the interpretation process, some sort of bias or some sort of not just fitting in so well. So we have to analyze these sort of things by the comparative studies.
Yes.
But not so many Japanese scholars also doing that, unfortunately.
You've got some very good ones.
Unfortunately, Japan Society of International Law also discuss in Japanese only. It's not so many scholars discussing English in the original. So that is also our sort of, I don't know.
Yes, I have no doubt you're right.
Yeah.
Language is a real problem.
Yeah.
I'm also aware that there are huge challenges for Japanese judges because they are moved. They sit in one prefecture for a number of years, 2, maybe 3 years, then they are moved somewhere else. The majority of your refugee cases are where? Tokyo. So if you're not sitting in Tokyo as a judge, you probably will never see a refugee case. And even if you do sit in Tokyo, you're only going to be here for a couple of years before you're moved on. I don't know how judges' families cope with it. Every 2 or 3 years moving around the country, that's a hard life. But it also means you don't get the cases, and you can't build up expertise, and you can't get trained. Because even if you get trained in Tokyo, in 2 years you won't be here.
No, just I think kind of a bias for the government because, as I said, the ratified convention as an international treaty is part of Japanese law, also superior to the Japanese local domestic law. So in this sense, in order to ratify, the government or even the Diet is very carefully examining the compatibility of the Japanese local law and also international law in this sense. That is why we ratified this refugee convention. We also amended this Immigration Act, then renamed Immigration Act, then the Refugee Status Determination Act, adding this process just for the implementation of the convention. So in this sense, the judges think all the ratified convention is really fitting in all in Japanese law. So in this sense, Japanese law is sufficient enough to refer. So, in this sense, we have to just, the lawyers should be more just open the argument with some sort of incompatibility or some kind of contradictions, especially to the interpretation things. Interpretation, because only the refer to the Japanese language, Japanese court decisions. So Japanese court decisions not so many times refer to the international precedent and so on. So in this sense, this sort of accumulation only for domestic reference. So they will not dare to examine the interpretation outside Japan, because this is annoying. It's it's an English version must be also examined as original. So it's not so easy for the Japanese practice as it's not a practical matter, it seems.
It does, but I don't think it's a
Just the president of Japan.
Yeah, it's not a popular convention here, I think, because you need to follow it in the spirit of what it is. But just as an example, and we'll talk about this Sri Lankan case a little later, but to say, as they've been saying for many years, that we don't, that the Japanese, when they signed the convention, didn't see themselves as being that bound by it. In that Sri Lankan case, the court there actually points out that they got advice back then from in the opinion of the Prosecutor of Civil Affairs Bureau of the Ministry of Justice, in other words, the very people, the Ministry of Justice, who were making the decision to decline the case, at the time when the Refugee Convention signing, admits other administrative agencies, that's people like the MOJ, to recognise and grant protection to those who have not been certified as refugees by the Legal Affairs Department, and the appellant's own claims made in the past in relation to it. So what they're saying is that you were told that you're meant to make decisions on it in the spirit of the convention itself. and that you've got to follow the convention. So that's the legal opinion given to the MOJ, their own legal opinion, doesn't hold up that argument. So that's really interesting. So that's why I think that case is really, it's not the easiest case to understand in the English translation, because it's obviously quite a complex Japanese decision, I think. But it really is saying some quite amazing things that at the High Court level, that really, I think, as we say in English, are the light at the end of the tunnel. What we've got to do, as Martin said, is get on the train and put it up to full steam and keep at it, or that's what might have to happen to make things change. All right, I think we've got, I'll just finish this comparison. I think that was all I needed to say. Yep, is there anything more on that? Yeah, I think anyway, just to finish it off, just for the comparison, in most common law countries, the first stage of interviews will be shared with shared information, and fairness and all the fairness issues often put in writing actually to claimants for their comments. In other words, you said this, you said that, I find this is inconsistent internally or externally. Please give me your reasoning as to why you have come to this conclusion. You said A when you were at the airport, you were saying B now. Can you explain why that is the case? These things are put to them at first instance because they can't be expected really to have the investigative skills or the legal skills of lawyers of taking witnesses through their evidence. Therefore, it's easier for them just to send it out and to get a written reply, which is very good when you're coming to the review decision because you have all that information there for building it in the future. So that's the usual way of doing it. And also on appeals, however, those three options I discussed above are pretty well the accepted way of doing it before, and all of them have strong fairness checks built into them. So in every occasion, if you want to get your decision overturned by a higher court, then don't just leave out some credibility point and don't give the other side the opportunity to contest it or to come back on it, and you'll get reviewed, almost certainly. That certainly in New Zealand, UK, every common law country, and fairly much in civil law countries as well. You've got to go through the basic fairness provisions, and if you don't, then you're not doing the job properly. And so you rightly will be turned over on appeal, which means your court, not you, most of the time, somebody else then has to sit down and do the case all over again on new evidence at another date, which is highly unproductive, as Martin and I know from running tribunals. So you don't want to have too many reviews over being overturned. So, and as I said, the final point on that really is, at the higher court levels, this is Court of Appeal, or you call it High Court here, it is almost totally a judicial review approach, finding an error of law and sending it back if necessary, or upholding it if there's no error of law. So that's why I found one or two of these decisions here quite strange, that a High Court, which is really expensive stuff, would go into the detailed factual analysis of a case, particularly when it's many, many years old, and come up with their own sort of credibility assessments as if they're primary investigators. It's different, very different is the best way of putting it. Okay, so we'll take a break now and till about 25 past, and then we can come back and we'll start looking at some real cases. In this case, in this situation, Sujin has kindly done an overview of 3 recent Korean cases, so it'll be good to have a look at those. And then Martin has spent the afternoon preparing his commentary on them, and so that'll be an interesting afternoon's work revealed to us. Just one thing that did come out of the meeting we had with the professors of international law that Sato Sensei and I went to the other day, and part of the challenge for academics like Professor Kitamura and so forth, interestingly, they said that, and it's the point you were talking about, international law being taken into it, that Japan is looking at bringing into its jurisdiction a special court for doing international copyright and international protection, IP, intellectual property, intellectual property protection work, because they're all bound by international conventions. Oh dear, and so if that happens, then from an academic point of view, there's a very strong case to be made. Well, why aren't you doing the same thing here? Just because that's the one that makes all the money for Japan, and this one might cost some money from Japan, it's still human issues, human dignity that's involved. So why aren't you doing it? Because I asked the professor there straight out, and I said, well, sorry, I don't buy that argument that you bring in one for intellectual property and copyright, but you're not. But as he unfortunately said, oh, there's not enough to worry about, or it's not important enough to deal with refugee issues. Well, sorry. I said, look, do you know the oath the judges give when they sign up for being judges? And that is, first of all, to uphold the rule of law and respect the human dignity of every person who appears before you, regardless of their race, religion, or whatever the other things that you might have in your law here. How can you do that? How is it any different from the wealthiest company in New Zealand and Japan appearing before you in an intellectual property case than a poor foreigner who's here and is claiming refugee status? I would be appalled if a judge did not give them the same weight or the same attention. So anyway, that's the reality of it, and that's where I think the academic side of it and analysis will be hugely helpful in the future. Okay, we'll take the break.